Welcome to This Explainer. Look, if you have ever lived in an HOA, you already know that keeping a community running smoothly is a massive, massive job. And when board members clash, well, progress doesn't just stop. It can literally turn your peaceful neighborhood into a battleground. So today we're zooming in specifically on Johnson County, Kansas. We're going to unpack exactly why these messy internal disputes start in the first place, and more importantly, how to use proven frameworks to resolve them without tearing your whole neighborhood apart. Okay, so here's our roadmap for today. We'll start with the roots of HOA conflicts, then move into spotting conflicts of interest, followed by legal duties and obligations, the homeowner's role, and finally, steps to resolution. Let's get right into it. Section 1. Roots of HOA conflicts. Most volunteer board members really do want what's best, right? But they bring totally different life experiences to the table, and that creates 4 main battlegrounds. First up, financial management. This is where you see huge clashes over hoarding reserve funds versus paying for shiny new projects. Then there's rule enforcement. Accusations of bias will explode if, say, one neighbor's parking violation gets ignored while another gets heavily fined. Then we have board governance issues, which breed deep mistrust when there's a lack of transparency. And finally, architectural changes. Denying a homeowner's property modification request, that can spark an incredibly bitter power struggle. Now, what's really fascinating is how regional differences dial up the heat. In rapidly growing areas like Johnson County, these disputes are usually fueled by a major clash of expectations. You've got a sudden influx of new residents demanding modern amenities, colliding head-on with long-term residents who just want to keep the neighborhood's traditional feel. Throw in the confusion over how to actually interpret Kansas state laws governing HOAs, and wow, you have a perfect recipe for internal conflict. Section 2. Spotting conflicts of interest. So a conflict of interest happens when a board member's personal life kind of bleeds over into their community job. And honestly, it's rarely malicious. A member might genuinely believe their cousin's landscaping business offers the absolute best deal in town. But advocating for that contract, that creates a massive perception of unfairness. Or imagine a real estate agent on the board using private HOA data to help sell homes. Good management means fiercely and proactively avoiding any situations that even look unfair. So what happens when a conflict actually does pop up? Boards have got to follow 3 strict, immediate protocols to protect the community. First, disclose it. The member has to explicitly state the conflict out loud. Second, step away. That member literally removes themselves from the discussion and the vote entirely. And third, record. You have to put that recusal in the official meeting notes. This protects both the member and the association from any future legal headaches. Section 3. Legal duties and obligations. When the drama really escalates, board members need a reality check. They are legally bound by fiduciary duty. They have to act in the community's best interest, period. This rests on 3 pillars. The duty of care means doing your homework, no rushed emotional decisions. The duty of loyalty demands putting the neighborhood way above your own personal wants. And the duty to act within authority means strictly following your governing documents. Guys, these aren't just polite suggestions, they are serious legal shields. And here in Johnson County, saying "I didn't know" just won't cut it. The Kansas Uniform Common Interest Owners Bill of Rights Act sets the absolute non-negotiable baseline for how your HOA must operate. We're talking everything from sending proper meeting notices to approving budgets. When disputes erupt over a rule change, turning straight to this statute is your fastest way out. It beautifully shifts the argument away from hot-headed personal opinions right back to cold, hard legal facts. But what if someone actually crosses the line and breaches those duties? Well, here is your objective, step-by-step game plan. Always start internally. Have a conversation, remind them of their duties, and document it. If the behavior continues, gather rock-solid proof and consult an HOA lawyer to assess your risks. Depending on your specific bylaws, the final steps might involve a formal censure or, in extreme cases, a special homeowner vote to officially remove them from the board. Section 4. The homeowner's role. Now, let's talk about you. A community is literally only as strong as the people living in it. But let's be real for a second. Venting to your neighbor over the backyard fence accomplishes absolutely nothing. Instead, use official channels. Submit a formal written complaint so it is officially on the record. Better yet, show up. Utilize the open forum at board meetings, collaborate with your neighbors, or just join a committee to actively participate in building a solution. And please, whatever you do, remember this golden rule. Put down the phone. I know it is incredibly tempting to just blast your frustrations on a neighborhood Facebook group or next door, but airing grievances publicly, it damages reputations and creates a highly toxic environment. Stick strictly to the truth, use those official channels we talked about, and protect people's privacy. By staying professional, you force the board to treat your complaint professionally. Finally, Section 5, Steps to Resolution. You know, chaos absolutely thrives when there's no structure. So, to break a deadlock, you've got to build some clear guardrails. Start using standardized procedures like Robert's Rules, so everyone gets a fair chance to speak. Set up dedicated HOA email accounts to separate board business from personal inboxes. And here's a big one. Reframe your language during meetings. Instead of pointing fingers and saying, John spends too much, try asking, how can we improve budget transparency? Attack the problem, not the person. Now, what happens when all that internal communication totally fails? You bring in outside help. But listen to me, going to court should be your absolute last resort. Litigation is incredibly expensive, it airs all your dirty laundry in public, and it hands total control over to a judge. Mediation, on the other hand, it brings in a neutral professional to guide a structured conversation. It's private, it's affordable, and it keeps the decision-making power exactly where it belongs, in the hands of your community. By prioritizing ongoing education, demanding transparency, and embracing tools like mediation, you can literally transform your HOA from a battleground back into a thriving neighborhood. You know the old saying, the best time to fix the roof is when the sun is shining. So take a close look at your own community today. Are your governing documents up to date? And really ask yourself, how prepared is your HOA board to handle disagreements peacefully before they spiral into costly legal battles?